Trademark law in the last 2 years has had a couple really big changes thanks to the Supreme Court. Several 6-3 decisions have basically allowed, well, some vulgar language to come in and, well, maybe some trademarks that don't actually treat people very well to be registered. How did this happen? Well, a couple years ago, a band called the Slants wanted to register the trademark, the Slants, in music. And it was rejected. Why? Because the slants was deemed to be some words that disparaged people. Specifically, it was deemed to be an ethnic slur. And a trademark under the statute that disparaged people was not allowed to be registered. Well, that went to the Supreme Court 2 years ago, and that was ruled down. Why? Because the First Amendment to the Constitution requires that anything that is speech related be content neutral. And in this particular case, the prohibition on disparaging trademarks was deemed not to be content neutral, right? The government could determine whether or not a trademark was disparaging, or in this particular case, where people of a certain ethnicity were trying to recapture a term. It's very complex, and ultimately it was a very messy 6-3 decision. Well, almost 2 years to the day, as a matter of fact, 2 years and a week to the day that was determined, well, the other portion of what could be deemed, say, immoral and scandalous, and therefore also not registered as a trademark, well, that was struck down by the Supreme Court also. That was because an apparel designer was filing the word F-U-C-T, I won't pronounce it, but you certainly can, for apparel, and determining and discussing the different kind of viewpoints that could express. Well, anything that was an immoral or scandalous matter not being allowed to register as a trademark, that was struck down. So now, if your trademark says, almost anything you want, as long as we're not really going to be deceptive about it, or we're not going to falsely make a connection with somebody else, that's perfectly fine. So we've now gone into a much bigger wild, wild west with trademark law. And so go ahead, let's file the vulgar trademarks. Let's file anything that might have some kind of disparaging notion. I don't really want you to express that viewpoint, but the Supreme Court said that those particular aspects are not allowed, and now it feels a little more like the wild, wild west, but feel free to express your viewpoints in your trademarks. I'm Anthony Verna, a managing partner of Verna Law, where we do IP and advertising law. Thank you.